All right, good morning, folks. How are we doing?
Good.
Good.
Any attorneys here? Okay, so one person seeking CLE credit.
Only, yeah, mostly. Most people see it.
Okay, yeah.
I have looked.
I spoke last week at a conference in Kingsport, and it was on workplace conflict, and there's about 20 people there, and I said, how many people here practice labor and employment law? Nobody raised their hand. How many people are interested in conflict in the workplace? Nobody. And I finally said, okay, who's just here for the credit? So everybody. So kind of had to wing that one. But what I want to talk to you today is about basically working with local bodies politic. And you'll find that I teach full-time for the Department of Political Science here on campus, but I've been a practicing attorney for over 2 decades, primarily representing bodies politic at the local and state levels. What you'll find when I talk to students and when I start talking about local government law, their initial reaction is, dude, who cares? What's going on in Washington? Not realizing that basically local elected bodies, cities, counties, have incredible power and authority. The ability to raise your taxes, cut your services, for which you normally have no redress. So that's kind of a challenge. But when I first started out, really 2 things primarily prepared me for a life in representing especially local governments. Prior to law school, I already held a master's in public administration. And that helped, I think, immensely in my government practice. And secondly, more importantly, I spent 10 years as a combat arms officer in the Army, and that truly helped me deal with local bodies politic, as you can imagine. Anyway, moving along. People have different perceptions, varying perceptions on governance, especially when you see things like government shutdown or some of the things that our legislators do. So we have a kind of a jaded approach. You'll talk to people and you say, you know, what do you think about Washington? I hate it. What do you think of Congress? Hate Congress. What do you think of your local congressman or woman? Oh, they're great. So we hate Congress in the abstract as an entity, but we kind of like our own elected officials as a rule. But Howard Baker was a proponent. He was a fan of governance, and he thought that the service in the public sector was indeed a high calling. And then there's kind of the opposite view about what some people think about politicians in general. And so you get that kind of divergence. Some people really are fond of government, others are not. In Knox County, just bring in a local level, people not pleased sometimes with the manner in which the county commission conduct itself, not pleased in the manner in which the city council conducts itself. Now, the way I've kind of structured this talk was geared towards people who are representing third parties who are seeking redress and seeking environmental justice through the local political process. But realistically, it just applies to the average citizen. You know, how do I have a voice? Is there a reason why I should even bother at the local level? And I think you'll find that there are some reasons why you should. But what's interesting about local government especially, it's kind of endemic. I've spoken at attended a lot of conferences across the country. And I've sat down with attorneys from everywhere from Florida to the South, Midwest, Far West. Recently I was speaking to a couple of local government managers and attorneys from Eugene, Oregon. And they had the same litany of grievances about local government, about state government, about the lack of cooperation, communication, the inability of people to actually get redressed, get basic information, transparency, ethics, civility. So it's endemic. So even though we may talk about our local scene, it translates well, I think, across the country. But when you look at the political dynamic, basically, some of the things to bear in mind about local elected officials. Now, the minute I say local elected officials, now I'm talking about generalizations. Obviously, there's going to be standouts. There's going to be people who actually sought local politics, sought local office merely because they wanted to improve their community. They weren't using it as a stepping stone. They weren't using it for personal gain. They weren't using it because they had a vendetta. They truly wanted to serve. So you have that mix. So if I sound sometimes like I'm being critical of clients past or the process, it does have some infirmities. And by knowing those infirmities, it assists you, I think, in actually going forward and seeking the redress you seek, or your client seeks, or the people in your organization seek. But they have very broad appointive powers, meaning they can determine who's going to be on the very boards and committees that control things like land use, planning, sewer, water. They normally will appoint these people. And even though they may be required to have an open and transparent process, sometimes that process isn't as open and transparent as we like to think. It doesn't really take a person who's been a political science scholar to sit in a public meeting and realize that the elected politic has already made a decision even before they started doing interviews. So they have these broad powers to do the things they want to do. They will often create committees just to justify that which they've already done. So they decide, we really need money to fund indigent health care at a local level. And they've already earmarked the money, they've already set it aside, they put all the mechanisms in place, and they thought, whoops, we may get some heat on this. Let's appoint a blue panel committee to kind of analyze this. And of course, they hand select the people they want. Those people come back with a glowing report saying, what a great idea, you should do this. They do it, and they move on. Again, this can happen. It doesn't happen all the time. It's not like it's constantly going on. But every now and then, people will raise an eyebrow, or the media will pick up something and say, what's going on here? Well, sometimes these things do occur. And the reason oftentimes it can occur more often in some place than another is apathy. Some people really don't care. So you get both ends of the continuum. You have people who truly are very in tune to the local scene, very watchful of that which is going, and others like, who cares? Then later go, what just happened? They will follow their own procedures. They can create their own policy, rules, and procedures. That gets very frustrating for lawyers sometimes. Many times I have sat with a body politic during a beer board, or a board of zoning appeals, or planning commission, and a person will come up who's basically been grieved. They're trying to seek redress. They bring their attorney, and the attorney starts objecting. Excuse me, objection. Counselor, we don't object here. Oh, well, I'm invoking the Tennessee Rules of Procedure. They don't apply here. Well, my client wants due process. Sorry, we don't offer it. And that you can see the frustration both with the attorney and the citizen. Oftentimes attorneys drop the ball because they don't sit there and one, look at the board they're about to appear before, and two, don't take the time to inquire whether or not there is an established rules of procedure that the board follows. And they vary not only from state to state, not only from county to county, but intra-county. The city procedures can be totally different than the county procedures. The makeup and compositions of the boards, totally different. And again, so people oftentimes harm their chances of seeking any kind of justice before a local body because they don't do their homework. They don't do their observations. They don't take advantage of the public records laws. They don't do their investigation. And again, I've seen attorneys create these blunders as well, not just a hapless citizen. Believe it or not, they're not always collegial. They don't always get along. There's infighting amongst themselves. That hurts because the citizens up there trying to get redress, and in the meantime, the elected body that's supposed to be granting this is too busy infighting because of animus and not getting along and political divisions and philosophy. And again, that kind of is distressful to some people. They presume they're going to go before a board that's well-managed, well-run, with an established rules of procedure that's readily available, that's collegial, that's there to serve their good, and they find out later that wasn't the case whatsoever, and they get jaded and think, the hell with this, I'm not going back, or in the alternative say, okay, now we've got to regroup and figure out what's going on with this particular board. Now, are there boards that actually are quite the antithesis of these? You bet. I have seen boards that are well organized, that are truly there for the benefit of the public, don't treat the public like they're an irritant. They have established rules of procedure that they give out in advance, they're helpful, they're patient, they don't cut citizens off when they're trying to speak, so they do exist. But it's better to be prepared for those that don't run as smoothly as that, just in the event you run up against some of these issues. And, believe it or not, they will form a committee, and they will ultimately ignore their recommendations to that committee. When Knox County decided to have the Hillside Ridgetop Plan, basically people worked for several years in that plan, produced a very extensive report, gave it to the commission, who turned around and said, don't like it, thanks for coming. That dissuades people from wanting to volunteer. That, good citizens say, why in the world am I going to put in my time and energy for free, only to be ignored? But they have the power to do that, and they will do that. And that's distressing as well. Because again, when they start forming these committees, you've got to kind of watch it to see what is their true intent. Are they forming a committee because they just want to punt the responsibility? Like, who wants to deal with this? It's an election year. I don't want to stand this. Hey, let's appoint a committee and let them handle it. Then after the election, we'll look at their findings, and if we like them, we'll employ them. If we don't, we'll just discard them. So this does happen sometimes. And again, it's not an indictment of the whole system. It's not an indictment of our local process here, but it does occur, and it's very frustrating for people, and it dissuades people from wanting to even approach government. One of the things that people don't realize, especially when I talk to citizens and my students at UT about getting involved at the local level, it's always, who cares, man? It's local. I want to know what's going on in the Beltway. That's the exciting stuff. Well, a lot of federal legislation can emanate from the local body politic, because local bodies politic will oftentimes work with their state legislative delegation, especially if they get along and are kind of like-mindedness. So local environmental legislation can ultimately turn out becoming law if people work closely with their state delegations. And of course, as we'll see later, counties and cities can pass laws of local effect. They're empowered to pass resolutions and ordinances that are enforceable, especially ordinances, in courts of law. So they do work closely with their state legislative delegation. If they don't, the question is why not, and what can we do about that? And sometimes they have to be questioned. You know, you go to them with an idea and they say, well, I'm not interested. I don't care if you're interested. I'm a citizen. I want you to bring this before the state legislative delegation, and I want to know when you're going to do it and why you're not going to do it. People need to make demands. Then, conversely, the state delegations work closely with their federal. And again, so sometimes these things that are seemingly innocuous that start at the bottom can actually work their way up to the top. Just today, in the newspaper, in the Knox News Sentinel, there's an article that says the state legislative delegation is requesting members of Congress, the federal legislative delegation, to meet with them in Nashville to discuss the shutdown and its implications for Tennessee. So people always say, the left hand doesn't know what the right hand is doing. Sometimes yes, but sometimes no. In this case, there's a hue and cry for that. So these entities can work together, and they can be compelled to work together if there's enough public and citizen input and interest. But again, apathy sometimes, because it can be frustrating to work with these groups, but it's basically having the old, stick to it and just pursue it and pressure them to do so. So what a lot of attorneys ask me and citizens say, basically, when we start talking about it, who cares? But if you don't know how these people work, either as a lawyer representing a citizen seeking redress, or if you're a citizen seeking redress or seeking a voice, seeking knowledge, if you don't know how they work, you'll just even get more frustrated, and you'll never get the redress you seek. Several things. By not knowing this, if you're an attorney, for instance, it's going to basically diminish your credibility in the eyes of your client and in the board. So if you don't understand how they meet, when they meet, what the rules are, for instance, if you wanted to go, let's say your client comes to you and says, look, I'm really interested in creating a greenway. I can't get a voice on this. What do I do? Well, the government attorney here should say, okay, who do you want to appear before? I want to go before the county commission. Well, that attorney should know that any citizen can come, call the commission office, ask for 5 minutes of time to go before the commission and present their case. It's up to the commission whether or not they want to engage in banter with them. They can just listen and say thanks for coming, but they can bring a PowerPoint, and within that 5 minutes they can ask for more time, and the commission has unbridled discretion to give it to them. It's televised, and believe it or not, a lot of people actually watch county television. And that's how a lot of these issues start making the rounds. The media picks it up and it starts to roll. That's how people get a voice. Well, if the attorney doesn't know enough to send the client there, or if the citizen doesn't know they have that right, because believe me, it's not something they widely publish, you wouldn't know that. Conversely, if somebody wanted to go before the Knox County Board of Education, the school board, totally different rules of procedure. They'll give you 5 minutes, but their written policy is, we do not engage you. So you can get up there for 5 minutes and rail against the machine and tell them all you want, and they'll say, thank you. They will have no comment, they will have no questions. Next. That's how they work. The county, on the other hand, will debate you. City, another set of rules. So just learning, determining who do you want to go before and what you seek to do is one of the deals. If you don't know these policy and procedures, the possibility of actually getting a positive result diminished incredibly. If you don't know how they operate and you find out, well, I went before them, they didn't give me what I wanted, I didn't get to set that green space aside, then somebody says, well, Why don't you appeal? I can appeal. I've had attorneys tell me that. I can't believe your county commission did that when I was the Knox County Law Director and when I was a law director in Florida for a larger county. I'd have attorneys lament to me, I don't believe them. They, screwed my client. And I sit there and say, you planning on appealing that? I can appeal. Yeah, counselor, you can appeal. Well, when and how? Again, they don't do their homework. And I said, well, actually, you could have appealed. The 30 days ran out 2 days ago. Too bad, so sad. So people don't do their homework, and they suffer as a result. And that's a problem as well. And again, you're going to minimize that probability of getting any kind of justice if you don't know the rules of the game. And that's just one of those problems we have. And I've seen both citizens and attorneys make these mistakes. They don't go before the right board. They don't know where their property lies, so they're before the city assessor when they should be before the county, or they're before the county beer board when they should be before the city. About 18 months ago, I was sitting with the Knox County Beer Board. Now, the Knox County Beer Board in Knox County is the county commission. And I saw an attorney sitting in the back with his client, and I didn't see him on the docket, so I walked over to him on the agenda, and I said, so you here for a case? He goes, I'll discuss this with your clients, thank you. I said, why don't you at least tell me what it is? He goes, no, I'm not going to let you preempt my argument. I said, I'm not going to preempt your argument, I said, I think I know who your client is. I said, I'm not even sure you should be here. I can be wherever I want. I said, fine. I went back up, sat on the dais. He brought his case. He started babbling on. I cut him. I said, counselor, what is the address of your client's property? And of course, his client's property was solely within the incorporated limits of Knoxville. He was before the wrong board. So I told the commission, I said, you cannot give this gentleman any redress he seeks. You don't have authority. I said, you don't have any say whatsoever. This is a city matter. So now the client's up there next to his attorney. He's like, what are you talking about? We're before the wrong board? I'll explain it later. You explain it now. Well, of course, the camera's rolling. It's on the record. And this attorney's giving me a dirty look. Like it's my fault. Like, hey, genius, tried to warn you. Well, for me, it was kind of a good day. I never liked him anyway. But on a serious note, what would have happened if that would have been someone who actually had a very timely environmental issue that they wanted to bring before a city or county commission prior to a vote, and they're before the wrong commission. By the time they get to the right commission, that vote's taken, it's gone. That law's been passed. So again, really want to be able to do your homework. That's why we have an open records law that I may get to later. But I've noticed over the years with citizens or clients, people normally have kind of two broad concepts of approaching government. Either one, you just can't fight City Hall. Why bother? They're a bunch of jerks anyway. I've watched television. I'm not going to deal with those people. So they're just apathetic or they're just discouraged. And I always tell them, look, maybe you can't fight them, you can wrestle them. Or they come the opposite way. They come demanding things, which of course really endears them to a local body politic. So either way, bottom line is people have to realize, yes, you can have a voice. Yes, you can challenge that which you're doing, but they don't have to generally give you the redress you seek. It just really depends on how the political winds are blowing, whether or not you make a good case, etc. So those are some of the challenges we have. Another thing I have found too, especially with, I've had citizens come to county commission meetings. I've sat in on city council meetings. I've looked across the state at this. What a lot of people don't do their homework is they don't call ahead and find out what about how they're set up with any kind of electronic devices. So somebody will walk in sometimes and they'll say, okay, I've got a set of overhead projector slides. And the clerk will say, we don't have an overhead projector, did you bring one? Well, no slides, sorry. Or they'll walk in and they'll say, I want you to play this CD. And it's not compatible. Or they have a PowerPoint and it's the wrong version. People need to think ahead. If you're going to go before a body politic and you're going to start giving them electronic stuff to upload, it's best to call ahead, get with the IT people and say, this is what I'm going to be bringing. Or call the commission secretary, the city council assistant and say, I'll be coming before the city council and the county commission. I'm going to be bringing some electronic stuff. Is it compatible? We don't know. Okay, fine. Who can I speak to? I've got a thumb drive. Who can I speak to? And meet in the building to test it. They will do that. In fact, they have an obligation to, even though they'll kind of hedge on that. People will oftentimes come to a commission meeting the day of the meeting with a 250-page portfolio, hand it out, and stand there and expect the commission to start reading it. They're not, okay? You may, if you give it to them in advance, maybe, it just depends how important it is. So again, it's just a lot of it is not really having an articulable argument as much as just realizing commonsensically, with the time allotted, with the interest level, what are these people actually going to look at? Will they actually sit down and go through a 200-page environmental report? Will they actually pay attention to that which you're giving them? Will they read it in advance? Or if you give them a 1-page with 10 bullet points, maybe that will at least whet their appetite and catch their attention. Just briefly, in Tennessee, again, we have basically 3 forms of county government. With 95 counties, so you're going to use the constitutional form. We have city-county consolidation. Metro-Davidson County, for instance, and Nashville is one. And out of 95 counties, 2 have charter government or home rule, Knox and Shelby. Knox County's charter is pretty much a carbon copy of Shelby County's with some minor tweaks. But again, people say, so what do I care? Well, bottom line is, if they're a charter county, charter, if you ever look at it, which is posted online on the county's website, is a mini constitution. That the commission can broadly change depending upon how it's structured. There are certain things they can change through ordinances. There are certain things that they could initiate a voter referendum on and put it before the voters. There are certain portions of it that the voters have to initiate, but again, it's a fluid document. It's a document that can be changed, either again, through voter referenda, etc. And that's important to know, because if you're a constitutional form of government, you're going to need a special act of the legislature to change the way you do business. Charter county, different story. Citizens can actually initiate it. You've seen citizen-initiated petitions. If you vote, you've seen them on the ballot, where citizens have come forward, gotten the requisite signatures, and said, we want to change the size of the commission. We want to change the manner in which we sell alcohol. So these things can be done, and likewise in an environmental setting. City governments, again, they have 3. And again, knowing what city, what kind of government they have. Do they have a commission manager? Do they have a council manager form of government, or is it mayor council? What's kind of the distinction? Well, let's say, for instance, you have mayor council, you're going to know that mayor is probably popularly elected. So you're talking about an elected official, a politician. Council manager, oftentimes the city council will hire a professional public manager or administrator. Kind of a different dynamic now. Now you've got an administration that is there generally on merit, that has some experience actually running a body politic. You may have a different shot at it. You may have a different kind of redress. You may have a different ability to bring your concerns before them. So these are the dynamics, the hand you've been dealt when you're trying to actually influence the way a local government's going to do things. County powers, and again, just locally, pass ordinances and resolutions, and basically not seek any assistance or permission from the state legislature. So they can pass a lot of ordinances and resolutions, and they can actually amend the charter through a voter referendum. Now, some commissioners, I think, are of the mind that they can just change the charter. They can't. That actually is going to be sent to the voters, but they can self-initiate. They don't have to wait for a petition. The commission says, we really need to change the charter on this issue. They can put the ordinance forward, and they can put it on the ballot themselves, and then ultimately the voters decide. And basically, when it comes to an ordinance, if it's not antagonistic to Tennessee general law, it becomes the local law. I distinguish between local ordinances and resolutions because the way the law distinguishes is between the two. An ordinance is basically a law of general application that applies within the confines of that county. A resolution is more of an express will of the commission than it is an actual law. The problem you have is that some court opinions interchange the phrases. Sometimes state legislation uses resolution the same. They really are distinctive. Normally, if the county commission wants to actually have something that's enforceable in court or that they can prosecute, they're going to pass an ordinance. They're going to use the resolution process more so for internal things, or we want to rename this street, so I hereby resolve through a resolution to rename the street, rename a building, etc. And likewise, cities are a little different. The legislature's always been a little bit more partial to cities. They have a lot of broad power and authority. Now, like counties, a lot of power and authority, but again, levy taxes, zoning for the incorporated areas, and other regulatory things such as code enforcement. So again, a lot of power and authority lies at the local level that oftentimes goes unchallenged and basically people are just unaware of. And by the way, this is a dialogue. If you have any questions, input, comments, anecdotes, feel free, please. But to give you some of the state legislation that applies, like for instance, Greenbelt. Tennessee passed this law back in 1976, the ability to have open space, agricultural open space, the Greenbelt law. People forget about laws like this and all of a sudden they become popular again and then all of a sudden they're acting as if, hey, there's something new. It's been around for a couple of decades. It's just that people sometimes don't show an interest or they don't know enough about it or no one takes the time to explain it to them and they just lie there dormantly. But the way the legislature crafted this law, when I say TCA for those who are lawyers, Tennessee Code Annotated, all of our laws are codified and you can find them online or in bound volumes, but all of these laws are there, which is kind of a daunting task because they vet about 1,400 bills a year through the legislature, and how many actually stick is another story and actually get through committee. But again, been there a long time, and the way it basically works, these are designed to basically improve the local economy, and that's sometimes how you have to pitch it to a local body politic. Because first of all, oftentimes you're going to have to go through the local property assessor, state, county rather, or city. But again, depending on where you are, consolidated or bifurcated system. But just when you approach a local body politic and they said, well, okay, what's this green space stuff? That sounds awfully scary to me. What is that? What are you talking about? To explain to people and show them some data. Look, this can improve the local economy, both residentially, commercial. A lot of people today, when they say, what intrigues you about moving to a certain area, they want to know about, of course, schools and what kind of green space do we have? What kind of parks? What kind of facilities do we have? You can explain to them, look, you're conserving very precious commodities, natural resources, the integrity of our water supply, air, the wildlife that, again, intrigue people and make them want to come to an area and reside. Having open land for the general welfare, trying to reduce urban sprawl, and basically just giving people the ability to have urban green space, which you would think is an oxymoron, but again, trying to find ways to approach a body politic and explain to them, look, we're not just merely trying to save a piece of land because we want to get a tax break. This benefits the local community. It encourages the right kind of industry we want, green friendly, environmentally friendly, to come and reside in our area and then grow along with us. And interestingly enough, the way that we generally see this, again, you presume to think, well, that's city and county. The state has always encouraged cities and counties to work together, to have these kind of memorandum of understanding, to have interlocal government agreements, to work together, to look at things more on a regional basis. Regional planning is getting a lot of legs now, and in fact, they've codified it in the state code. Basically said that we have it set up to where we should have compacts and contractual relations, permitting cities and counties to work together, to provide services, to provide not merely emergency services, but provide matters in which cities and counties can work together for a common goal. So a green space doesn't end at the county line or doesn't end within the corporate limits of the city. They work together. So getting the two bodies to cooperate, of course, is always going to be a challenge. Yes?
Are you mentioning the Greenbelt thing because of the recent controversy about golf clubs, golf courses?
No, I didn't use that as an example. I just think that green space is something that, for a while, for instance, in a lot of counties across the state, people started thinking about green space. Well, then they started hearing about something called Agenda 21 coming out of the UN. And they said, wait a minute, Agenda 21, I've heard about that. They're coming to seize our land, they're trying to tell Americans how to use their land, and they started equating that with green space, started equating that with blueways, and they started putting it together in this melting pot and saying, so now when a lot of the more conservative bodies, politics started hearing things about green space and open space, oh, I know what you're thinking, you're pushing out Agenda 21. Hillary Clinton signed into law. No, she didn't, no, she can't. But it's another story. I've been to meetings, I've heard people come in and tell bodies politic that story, or tell them that green space equals a communist takeover of America. So again, it's trying to educate people, trying to get them to work together. trying to get them to cooperate. So that's the challenge. Now, when we talk about all these boards out there, boards and committees that governments create, that can actually affect the manner in which they conduct themselves, the decisions they're going to make. There's myriad of these things. Some of them are merely advisory. They get a group of citizens together and they say, look, here's an issue, review it, do a paper or do a presentation or PowerPoint, whatever. Just get together and tell us what you think. Merely advisory, they can ignore those findings, they can approve those findings, they can use them as an excuse. We were going to do this, but our advisory board said we should. Or we really don't want to do this, but the advisory board said we should. So sometimes it can be used as a tool, but sometimes it's candid and sincere. We don't know enough about this issue. You say it's important. You say people care about it. Prove it. So they appoint a committee and they say, tell us what you're going to do. Some are quasi-judicial. Now what does that mean? Basically, they have some rulemaking authority and they have the ability to take away a property right. So let's say, for instance, you take a beer board that can license you or determine whether or not you're going to get a beer license to sell beer in the city or the county. Well, that's a quasi-judicial board because they can sit there and say, you don't get a beer license, or we're going to revoke your license because you sold beer to an underage minor. If you look at some of your zoning boards of appeal or code enforcement boards that can impose penalties, they're quasi-judicial. They're acting pretty much like judges with the ability to fine you or take away a property right. So again, I've seen attorneys and private citizens make the mistake of not taking a close look at the board they're dealing with. You know, they'll show up at the meeting and they'll say, we want to attend the board meeting. You can't. What do you mean I can't? I thought we were an open government state. We're not a sunshine board. We're just an advisory board. There's no elected official. Go away. Or on the alternative, well, I see 2 of my county commissioners on this board. I'm staying. So it's just knowing how it works. But again, some of these boards have a lot of power and authority. And again, have the ability to take away or grant a property right. Some of them are mixed. Some boards are purely elected officials. Some of them are a mixture. You look at some ethics committees across the state that local governments have. It'll be a mixture of local elected officials and private citizens together. Again, that changes the whole dynamic of the board. Some of them comply solely of elected officials, and some are citizen volunteers. So everyone, there's a myriad of these boards. There's really no rhyme or reason. There's only a few boards that by statute, by Tennessee code, that actually dictate the manner in which they have to be comprised. But oftentimes, there's a lot of broad discretion amongst the bodies politic to determine this is going to sit on this board, we're going to appoint them, and too bad, so sad. Just how it is. Then there's also committees. There's going to be statutory committees, and basically that means Tennessee code mandates them and dictates how they're going to operate. Also, these standing committees are usually there. Those are internal, and those are always there. So, for instance, for the longest time, both the city and the county had cable TV committees. They're just standing committees, are always up to something, or they're dormant, doing nothing unless something comes before them. And then again, special committees, usually not mandatory, usually internal, usually appointed by the commission. And again, that's one way of addressing citizen redress, depending upon the motives of the body politic. Should we have a special committee to look at this? And if so, who should be sitting on this committee? Should it be just private citizens? Should we have a mixture? Some states are very specific. For instance, if you go to Florida and you want to sit on a planning commission that actually determines the manner in which that county or city is going to regulate land use and planning, by law, there has to be a certain makeup of that board. It dictates it in the Florida code that one person has to be from the environmental community. 2, person has to be a realtor. 3, an agriculturist. 4, a person from the local business community. But they're all appointed, no elected officials allowed. So that's just one state. Georgia has a kind of a hybrid, the manner in which these boards are created. So again, sometimes these statutory committees are just that. Statute, state is going to determine this is what the body consists of, this is why it's like it is, and that's how it's going to conduct itself. Again, I just touched on this a little bit, looking at it, when I say an attorney or a citizen wants to know if they're sitting in a quasi-judicial legislative capacity, it's basically the way it works is what the courts have said is if they're making new law, then we're talking about legislation. If they're enforcing pre-existing law, then they're quasi-judicial. Most of the boards you're going to deal with are going to be quasi-judicial. In other words, zoning boards, beer boards, because again, they're just applying the law as it's stated. They're not trying to create new law. They're not trying to change the law. So most of the time when you're appearing before a board that actually can affect a property right, you're talking quasi-judicial. I just threw that in for people who are actually needing continuing legal education. But here's an idea, just like, let's look across the county, Blount County. Some of their boards and committees. Myriad, Cable TV, Sheriff's Merit Board, Beer Board, Planning Commission, Adult-Oriented Business, dealing with sexual-oriented businesses and their licensure thereof, Education Committee, ad hoc committees. This is just one county, and again, and this is not all of their boards, this is merely a sampling, and that's just the county, that's just Blount County. Let's look at the city of Maryville. Some of theirs. Regional Planning Commission, again, notice you've got a planning commission in the county, you've got a planning commission in the city. Historical zoning, Board of Zoning Appeals, Tree Board. Point is, there is a lot of committees doing a lot of things that oftentimes are under the radar. People don't attend these committees. When they notice them, rather than, people presume, well, how come I didn't know about that meeting? And the city's or county's response is, well, we published it, we noticed it according to state law, which requires us to take a piece of paper and tape it to the bulletin board in the county administration building. What'd you expect? Personal letter? Sometimes they don't advertise them. They don't make an effort. And that varies from county to county, state to state. There are some states that if they're going to rezone a piece of property, they will send certified letters to every resident that's affected. Others will send a postcard. Still others will post a sign in the dirt. Going to be rezoned. Oh, you didn't see the sign? Oh, it blew over? Too bad, it's a sign. Sorry you didn't see it. Yes, we rezoned it, and yes, we're going to put in a aggregate living facility for drug offenders next to a school. That's your problem. What? So these things happen. Here's a sampling closer to home, Knox County. What the county can do. These are just some of the things Knox County can appoint members to. Board of Adjustment, Agricultural Extension Committee, County Board of Health, Public Building Authority, Sheriff's Department Merit System. Again, this is only a few that the county commission can make appointments to, and with or without citizen input. They don't need citizen input whatsoever. They can just sit there and say, this is the committee, we're sorry you don't like it, but that's what we're doing. This is what the city can do. Again, I know that after a while you say enough with the committees, but the point is, we presume to think that every single decision being made in local government is being made by the city commission, city council, or a county commission, regardless of your county where you're living or city. You presume to think, well, my elected officials are making the decisions that affect my life. Not necessarily. If they delegated that authority and the statute allows them to, you've got other people making these decisions. So they're going to determine whether or not we're going to cut down 200-year-old oak trees. A group of citizens. Whether or not you get a fair hearing at the Fair Housing Board. Who are these people sitting on these boards? Are they there because they understand the Fair Housing Act and because they're looking to really help the citizenry, or are they political appointees who called their local commissioner or council member and said, I'd really like to appear on a board, it would look great on my application for future use on my resume, can you get me on something? Yeah, you're on the Greenway Commission. Hey, thanks, what is that? Don't worry about it. I mean, these happen. And then other times there are people who are sitting on these boards that are very educated, intelligent, well-meaning. So again, it just really depends. But just to give you an idea, there are a lot of them out there with a lot of power and authority, and very difficult to challenge that power and authority. I've seen a lot of frustrated people leaving these boards and commissions because they presumed they could speak. Or, I don't want to speak to you today, I'm not a good public speaker, I brought my lawyer. No, we don't want to hear your lawyer. We'll hear from you. I just paid this person $300 an hour to speak for me. Tough. Yeah. And they can do that. And you can't do a thing about it. So again, it's really good to know who you're dealing with. When I say practice tips, I know this is going to be more geared towards lawyers, but I think we can translate this into non-attorneys as well. Again, as I mentioned earlier, study the issue. Should I be before a state board, a county board, a city board? Should it be county or city? Where does the property begin and end? Is this the right decision making? It sounds like it, but is that the case? Board of Zoning Appeals. Okay, am I actually appealing something? I really don't want to appeal. What I want to do is change my land use designation. Should I be before the Metropolitan Planning Commission? So getting before the right board and committee is the first step. After you get before that committee, you're going to want to know exactly what their power and authority is. Sometimes you sit there and you think, oh, okay, I'm going to appear before the BZA. I'll just look them on the internet. They're not listed. How come they're not on the website? Then you call and say, who's in charge of the BZA? Well, that's so-and-so. Well, is it on the web anywhere? No. Do you have rules of procedure? Yes. Can I get a copy of them? If you come down here, we'll give it to you. It's $1 a page, whatever. So you can't presume that with the touch of a key stroke, you can get that information. But you're going to want to know who's sitting on that board, what their power and authority is, and what their rules and procedures are. Can you bring a lawyer? Can you go by yourself? Do you get 3 minutes or 5 minutes? Is it discretionary? Do they make exceptions for people they know? Is it consistently enforced? If you get up, if you're waiting your turn and the person goes up before you and the commissioner goes, Frank, good to see you again, what you got? Well, I got this little issue, take your time. Then you go up, who are you? So-and-so, you got 3 minutes. He got 10. So, I mean, who are we dealing with? What is my redress? Are they, and you think to yourself, yeah, that's going to happen. It does happen, okay? That's not an indictment of our local area, but I've been across the country watching these and for about 23 years now, and I've seen things that have just astounded me. Just like, okay, I guess we're a little inconsistent here. Is this a board that actually has, rulemaking authority? Is it mandated, or did the board, the commission or city council or the public entity just make it up? Say, well, we created this board. Because again, that makes it a lot more difficult to find out what the power and authority is. I always advise people, look, if you're going to go before one of these boards, don't go in cold, backbench it, sit in the back of the room. I used to tell young lawyers, they'd say, oh, I got this judge in the morning, I've got a hearing, what time's your hearing? 1:30. I said, then get there at 9. Sit in the back of the room, watch the judge, watch the clerk, watch the other lawyers, and learn. Oh, hey, great idea. Well, sometimes it's wise just to sit in the back and watch how they work. Contact the county and say, do you televise these things? Well, no. Are they taped? Can I get a copy of the disc? Just watch the machinations and watch the manner in which they conduct themselves. You want to learn, basically, are they the end all? Are these the people who make the decision as the buck stop with them? Or do you have a right of appeal? Can you sit there and say, okay, I know how they work, and I know the manner in which they conduct themselves, but I also know if I don't get the redress I seek, then I can repeal it. And another key is, you want to learn, when I say your clients, or as a citizen, to whom do you appeal these things? I've had more than one attorney, rather experienced attorneys, tell me, counselor, I'll see you in court after an adverse ruling. And I'll say, you won't see me in court. Well, I'll see one of your assistant attorneys in court. I said, you're not going to see anybody in court. I said, do you know where to appeal this to? Well, I'm going to take it across the street to the courthouse. I said, good luck with that. And I said, no. I said, you have to appeal this to the county commission. What are you talking about? They created that board, and I'm going to appeal to them? I said, yes. Before you can get to a courtroom, you've got to go before the administrative appeals process, which requires you to first exhaust all your administrative appeals, which means you're going to go from this board to the county commission. Then, if you don't like what the county commission does, then you can go to court. And then there are certain rules and regulations that actually are quite the opposite. You don't get the redress you seek, you go right across the street to the courthouse or downstairs or wherever you live, but you get to appeal directly to a judge. And it's knowing that. And again, these things are time sensitive. They have oftentimes they're 30 days, sometimes they're 45 days, sometimes they differ between counties if it's not state mandated. So you may be in one county thinking, this is a cinch, I've done this 3 times in Sullivan County, I got 45 days to appeal. Then you decide to help your friend in another county, don't worry about it, we got 45 days. Day 31 comes up, you find out in this county, it's 30 days, too bad, so sad. And you walk into a judge and say, Your Honor, I didn't know. That's too bad, thanks for coming. It was 30 days, this is day 31, you have lost your ability to appeal, boom, you're out of court, you're out of luck. So, again, it can be a very complex process, but again, going through it. And again, presuming that these boards possess a certain level of technical expertise or skill, sometimes they do, sometimes they do not. Sometimes your people you're speaking to really have no idea what you're talking about, and sometimes you have to just say to yourself, we're going to go through the drill just so we can get to the next higher level. We'll do the dance, They don't care, they don't understand. Let's put our best foot forward, create a case. Then when we get up to the next higher level or to a judge, then we can make our case. But I've seen people walk in and they'll go, you have no idea what I'm talking about, do you? And they walk off. And I'm thinking, no. Stand there, try to educate them, be patient, even if they're looking at you or they're texting to somebody else doing the crossword, build your case, then go on. If, however, they're the final determinative authority and you still don't think you get redress, sometimes you've got to actually file a claim against the body politic. Some of these boards and committees actually have mandatory training. The statute requires members of certain boards, like boards of zoning appeals, certain land use boards, to actually have training and have it annually. It's always good to determine, to do a little checking on that and ask, when was the last time the members of this board were trained? Sometimes they'll say, well, annually. In fact, here's the report. We just filed it with the state. And others are like, oh, mind your own business. That's probably a clue. They haven't been trained. And then now, are they a valid board? So that's always a challenge as well. Again, I mentioned this earlier, some will actually go through amazing hoops so the public knows what they're doing and when they're doing it. Others, you're on your own, too bad, so sad. Sorry I didn't hear about it. I could have sworn we posted that property. You've probably seen the debate just here locally about whether or not a certain board is a sunshine board. In other words, do they have to adhere to the open records law? That means that they have to notice their meetings, make them open to the media and the public. Does that mean if you require documents, they have to give them to you? And that's always good to know as well. Because, again, I've seen a lot of frustrated citizens come to me, when I was in private practice, come to me and said, I want to go to that board, they wouldn't let me in the room. And I'd sit there and say, what's the board? I do a little research. They don't have to. They're not an open government board, they're not a sunshine board. They don't have to let you in. Well, it's an outrage. Yeah, it is. It's the law. Also, one of the big things I see, people presume to think that they're going to follow the Tennessee Rules of Civil Procedure or the Tennessee Code of Evidence Code, or basic due process, and sometimes they follow none of the above. They have procedures they follow, but never really took the time to codify or write down, so you really don't know how the rules are, hence the reason you should kind of keep an eye on them and watch them from afar before you go. But again, I've seen a lot of experienced attorneys, rail against this. They sit there and they say, that violates Rule 20.2, the Rules of Civil Procedure. And the board member will go, what's that? This is an outrage. What do you mean? The Rules of Procedure. And I say, Counselor, they don't follow the Rules of Procedure. What rules do they follow? I said, well, they kind of make them up as they go along now, don't they? And they do, sometimes. I've mentioned this already. Some of them will say you have 5 minutes. Others will give you a little extra time. Some will cut you off in mid-sentence at 5 minutes or 3 minutes. And the courts have said that's fine. The court said you can put a time limit on it. Like I said, some are set up with electronic media. Some will actually look at what you've done. It says some committee members welcome ex parte communications. When I talk about ex parte communications, basically it's speaking to the members of the decision-making body outside of the public meeting. So you call your commission, say, look, Monday I'm coming before you. You know this is a good idea. Now, some of them will sit there and say, oh, well, I'll tell you what, I'll meet you out there at the property. And if one of them does that, it's fine, it's legal, but the state attorney general has said they better disclose it. Now the problem is with an attorney general opinion is just that. Attorney general opinions are opinions, they're not law. They don't have binding effect of law. But the attorney general has consistently said it throws a pall on the procedure, it gives it an aura of impropriety and patent unfairness if they don't disclose their communications outside of the body. But must they do so by law? No. And therein lies the problem. Many times I've seen citizens come before a commission and they're up there waiting for their turn, and then all of a sudden they see the opposing party up there talking, they go, wait a minute, I just saw him and him at Starbucks yesterday. What's going on here? And then they challenge it, they say, well, that's none of your business. We weren't talking about your case, we were talking about something else. And that's just the way it is. Basically on appeal, again, what I tell either a citizen, don't presume you're going to getting to go right to a court. Like for instance, Blount County, 90 days. Knox County, 45 days or 30 days, depending upon where you're before. So again, knowing to whom you have to appeal, and that appellate process is another story as well. Now, what I mentioned kind of earlier on about citizens' opinion of government, either you can't fight City Hall or in the alternative they owe me, one of the things people have to realize about local government, okay, they can sue and be sued. It's a public corporation, so you can sue government. You can sue for redress. And they're sued quite frequently. Civil rights in federal court, personal injury contracts. You'll find that counties and cities sue over breach of contract. They'll sue if somebody destroys county property. But the converse is, citizens have a right to sue for these and myriad of other things. So there is redress in the courts. The courts do limit liability in personal injury cases under the Government Tort Liability Act. Actually, I think I have a slide on that, but basically, that just tells you there is limits on cases. One thing you do need to know, if it is a personal injury case, you're going to be trying that case before a judge, not a jury. But anyway, that's only if you have a single plaintiff. If you have multiple, it's a whole other story. Point is, what I'm just trying to make the point here is that government can sue and be sued.
I have a question.
Yes.
Can you sue a governmental body or commission for not following, it's not the board itself, but the city government, for not following its own internal procedures before it makes a decision?
What people have done is they filed an injunction. And we hear the word injunction sometimes. First thing we think of is domestic violence. But basically an injunction in the law to enjoin someone is to compel them to do or not do something. I have seen people file with the local chancery court or circuit court a injunction asking the court to compel the body politic to follow its own procedures.
What if it's already made the decision
Then
and didn't follow its own procedure?
There's a presumption that the body actually acted properly, but that presumption can be overcome if you can actually show that there was bias and they failed to follow their rules of procedure. That's the reason I think a lot of bodies kind of forget to publish their rules of procedure so they can't be accused of not following them. But yeah, I mean, it's a viable cause of action. It just really depends on how the courts view it. They'd have to show that by their failure to follow their rules of procedure, that person was deprived of a property right or an interest. If the court just says, yeah, well, they didn't follow the procedure, but the outcome would have been the same, or no harm, no foul, it just really depends on the court. But the ability to bring an injunction, yes. And
one more point I wanted to make as far as your practice tips. I think it's important too to have a physical record of when you go before a body, to have your if you have documentation, anything to have in that record, so that if you do have to appeal, you've at least got the materials that you gave to that board or council or whatever, and make a written record.
it's an excellent tip. It's something you should take to heart. It's always wise if you're going to go before a commission. It doesn't matter if you give them something and you literally see them fling it aside like we're not interested. You just tell them right there, I want the clerk to enter this as my exhibit. The clerk then has a duty to do so. The clerk can't say, well, they don't want to read it, so I'm not going to enter it. Yes, so there is a record of it. It is now in the clerk's minutes, and that establishes your right of procedure. Excellent point. Very good. Appreciate that. A few things about open records. Basically, this keeps evolving, as you can imagine, as media changes. But what the courts have said, basically, is that any of these things they create that have to deal with the transaction of official business becomes public record. Now, every now and then you'll see an odd case where some elected official will say, well, you can't have my emails because even though I might have used a county computer, they have nothing to do with the transaction of county business. They were private, and the courts still wrangle with that. In some states, every state is different in terms of how they view that. But bottom line is, most of the information produced by local governments in Tennessee should be available to you. So basically, when I say one of the biggest advantages of a plaintiff's lawyer, basically one of the biggest advantages of any citizen who has a case is to make a demand and demand copies of those records. And again, they have to make them available. if they, now they don't have to necessarily copy them and mail them to you, and they can charge you a reasonable fee, and they can even ask you to clarify that what you're seeking, because again, there are people who will ask for things and they really don't know what they're asking for. Over the years, I've had citizens or attorneys call for and say, I want all of the driver's license or all of the business licenses issued from 1992 to present. And we'll tell them, you're entitled to that, but it's also 50,000 pages. At a dime a page, you sure, whoa, wait a minute. What I really want is just sexually oriented business. What I really want is just cable companies. So you can work with them in that aspect, but they either have to make it available for you to come in and open up the book and say, here it is, or if they can't within 7 days, tell you why they can't provide it. Either they don't have it, or it's been destroyed, or it's going to take them a while to amass the information because it has not been digitized or et cetera, et cetera. And also, it's always a wise idea to, if you get an issue, let's say you have an environmental issue, and you know you're going to go to the mattresses, you're going to go to war with the city or the county, you start right out by sending them a letter saying, look, you have a duty to ensure you do not destroy or otherwise get rid of the information I'm about to request. It's called spoliation in the law, but basically you're putting them on notice. I'm going to be requesting documents related to this issue, and they better be there. Because by doing so, you can go into court and say, Your Honor, we know for a fact that there were about 100 emails between the city council and this developer, and now all of a sudden they're gone. We have a feeling we have a spoliation issue. And the court will say, bring them in and say, did you have these emails? Well, we did have them, but they somehow disappeared off the server. Fine, and we'll get a forensic computer expert from the FBI to come in and see if we can reconstruct those. Oh, you can find them after all. That's helpful, thank you. So, it depends. Again, one of the things as well that people have to realize, in Tennessee, you have to be a citizen to make this demand. So, if you're an environmental group and you're in Ohio and you say, give me these public records, the city or the county or the state can, by law, refuse that request and say, you're not a citizen. They could make you prove citizenship and say, not a citizen, you don't get it. And I've gotten more threatening letters over the years from people when I was representing Knox County, from entities outside of the state. They, I'll give some lawyer send me a 2-page letter about the law. First of all, they would cite the Freedom of Information Act, which is a federal law, doesn't apply. And after they got done exhausting that, made all these demands, and I write them back and say, sue me. I say, here's the law. You still think you have a claim, sue me. They go away. Because again, Tennessee is one of those odd states that actually makes you prove citizenship. Other states, a lot of states do not do that. They can't refuse you access to these records. Of course, there are a myriad of exceptions to the records, everything from social security numbers to personal addresses of certain law enforcement personnel. But if you're entitled to it, they can't yank your chain. Like, well, why do you want it? It's none of your business why I want it. And that happens. Sometimes public employees get territorial. They don't, well, what do you need this stuff for? I think I'll hold on to it. Like I said, there's exceptions. Information can be redacted, so sometimes there are things that must be, again, like certain personal information, addresses, phone numbers. But again, the whole idea behind the Public Records Access is to give people access to that which the government is doing. Likewise, we have the Open Meetings Law. So what does that tell us? All meetings of any governing body are declared to be public meetings. Now, the big debate always comes down to, well, we're not a governing body. What's a governing body? What does that mean? And what do the legislatures say that means? Well, they basically, I'll get back to that in a minute, but basically, meeting is a public meeting when you have a quorum required to make a decision, to deliberate. And again, governing body, any public body can have 2 or more members. So if you've got 2 members of the county commission and they're talking about an issue, it better be noticed because it's a public meeting. And they're violating the Open Meetings Act if they're doing so. There's exceptions if they have a chance meeting in a store and they're not discussing county business. But again, where I think people make a lot of mistakes, I used to get calls all the time, I just saw the school superintendent talking to a city council member, what are you going to do about it? Nothing. First of all, the school superintendent's appointed, and second of all, he can talk to anybody he wants to. Well, I saw the chairman of the county commission talking to the city mayor. What are you going to do about that? Nothing. 2 different bodies. They've got to be the same governing board. and that would upset people, and I don't blame them, but again, that's how that works. They have to give adequate notice of their meetings. They've got to record the meetings. Now, when people see this, that doesn't mean they have to have a tape recorder. They can literally have somebody there with a notepad taking notes, but they have to be, it has to be recorded. There has to be an established agenda, etc. So, again, they have a lot of strict requirements, and no secret votes. It's got to be made during the county committee. They can't vote in secret. They can't deliberate in secret. We all know it happened in Knox County and other counties. People have been removed from office for violating this rule. But again, there are exceptions. This is interesting. The state actually made exceptions specific to Knox County. County commissioners were basically saying, it's kind of absurd we can't communicate with one another on issues of importance. And they said, fine. So the legislature created this exception. They can actually email one another, but it has to go through a server, it has to be made public, and it has to be open and available. Bottom line is, Knox County gets this exception. It was rather underutilized by the commission. It's rarely used at all, and not one other county in the state said, hey, we want the same law. So, you can reach your own conclusions there, but the bottom line is, they didn't like it. It just didn't work for them. Some of them did initially, but really, again, the idea that people were able to monitor the communications, I think, might have had something to do with that. I don't want to speak for them. I don't know what their intention was or their reluctance to use it, but it just seemed to be very underutilized. Some of them did see the merit in it, some did not. But again, Feather O'Connor said, government is moving towards transparency in fits and starts. No one seems to be able to point out key tools that will accelerate the process. Whoa, I think I just ran over time. Anyway, bottom line is this. I think they'll make these this presentation available to you. I certainly sent it to them. If I could sum up quickly, bottom line is this. If you're seeking redress before a local body politics, several things to remember. One, local bodies have a lot of authority and power. Two, they work with state legislatures and with federal legislators, so oftentimes local issues can become law, either countywide, statewide, or even federally. Know before whom you speak. Know the power and authority of the board. Know its composition. Know who's on it, how they make decisions. Knowing that and educating yourself, knowing how to appeal if you don't get redress, are all key ways to ensure you're going to get some redress and possibly a possible outcome for environmental justice. I'll stand for questions.
A couple of observations. It's been my experience in dealing with Jefferson County, which is a non-metropolitan county, that if you want to have something happen in county commission, you need to be talking to commissioners individually before the meeting ever happens. Because when they're in the meeting, their minds are already made up. They go through the formal process of voting on something, but there is no discussion, generally speaking. There's no debate. If you speak in front of them, in that public forum, they will politely listen to you and then go on their merry way. The other observation...
Before we go to the next one, first of all, I think it's endemic, and I think it's always an excellent idea of building personal relationships and taking time to speak to each one individually. Because again, that assists you in at least educating them and taking the time. It's out of the glare of the public meeting. There's no notice requirement. You can sit down by, have a cup of coffee with them in a restaurant, and there's no open records issues. There's no open meetings act issues, and that's exactly that's an excellent idea. Yes. Number two.
You need to keep in mind that generally the opposing side, the side with economic interests at stake, does do this on a regular basis. I know for a fact that the executive director of our Chamber of Commerce made it a habit to once a week take a commissioner to lunch, and just did that throughout the year. The other observation I wanted to make is that there are no qualifications for elected officials. And at least in rural counties, I can't speak for Knox or the other metropolitan areas, most of your commissioners have a general educational level of about maybe 8th grade. So you don't want to come in front of them trying to overwhelm them with your sophistication and skill set, because they will take offense at that.
I agree. That's why I was saying earlier, you should know before whom you speak. Know who they are, know how they operate, and trying to build you can't ever go wrong building personal relationships. You try to ambush or embarrass them, you'll get nowhere. Excellent observations from everyone. Anything else? Can't believe you came here at 9 o'clock in the morning, but thank you for your courtesy and attention.